Here is the paragon of law and serving the people of Carmel with honor and grace, City Attorney Brian Pierik. For 3 years and counting, Mr. Pierik has done everything in his power to conceal records from me which were always within my right to obtain after I was arrested twice by the Carmel Police Department for standing on a public beach. These are just a fraction of some of the crimes this attorney has committed. This is when I asked for a copy of his bar card, which is a public record. His legal advice to Carmel employees is to lie and tell me there are no records. The next day, he tells them to lie about it again. This request has to do with Carmel employees and Brian Pierik concealing signatures on their oaths to office, which they have done for years. And what's the most embarrassing for them is the code they use as their authority to conceal the signatures is actually the one that compelled them to disclose their oaths in their entirety with signatures visible, which I will cover in another video. In this request, I wanted an inventory of everything seized from me during my arrests, all the documents that were purportedly used to prepare for the warrant service, the certificates proving the police officers had the authority to even arrest and search me based upon a warrant, and the identities of all the officers involved. In a response, Mr. Pierik cites government codes as his authority, which have nothing to do with the records I requested, which he did all the time. And later when I write, I am unclear as to what you are trying to convey. Does this mean the records exist, but you will only produce during discovery, or they do not exist at all, and even in discovery will not be produced? So I'm asking for clarification. He answers, what records, if any, may be available through discovery would be addressed at the appropriate time. In other words, we're not going to tell you what property we seized from you, whether the officers prepared for the warrant service or they didn't bother, whether or not any of them were even certified to arrest and search you, or even the identity of the officers involved. And again, here's a fraction of responses he sent me for a year and a half, denying all the body camera, dash cam, and video surveillance footage of my arrests, including the video a female officer by the name of Lisa Johnson recorded on her cell phone of my arrest. And he does this by citing nonsensical, unrelated government codes and case law, specifically Haney v. Superior Court, which has nothing to do with my request for her cell phone footage. Well, Mr. Big Shot Attorney and the employees of Carmel probably never thought in 1,000 years I'd find the seminal case of City of San Jose versus Superior Court, proving that his response is yet another lie. This was a unanimous 2017 California Supreme Court ruling, which was covered by Columbia University. The California Supreme Court, reversing the Court of Appeal, held that email communications on private accounts by public officials are public records and thus subject to disclosure under the California Public Records Act if related to the conduct of public business. The privacy of the city employees did not outweigh the interest in transparency of public business as stated in the California State Constitution. The court was concerned that if public officials could circumvent the law simply by using a different email account or communicating through a personal device, sensitive information could routinely evade public scrutiny. The court ruled that transparency in government activities was essential, and while it was important to be sensitive to the privacy of public officials, this did not justify a categorical exclusion of all communications on personal accounts, especially when personal communications unrelated to the conduct of public business could be redacted and excluded from public disclosure. And I incorrectly noted the citation in the email, but this is actually the correct one, the one that's in blue. And this is a quote from the case, which must have really chapped their ass. As to requests seeking public records held in employees' non-governmental accounts, an agency's first step should be to communicate the request to the employees in question. The agency may then reasonably rely on these employees to search their own personal files, accounts, and devices for responsive material, proving that it was black-letter law to tell Lisa Johnson that she didn't have a choice about disclosing that video she made of my arrest to her superior officer, which they were then required to disclose to me. So when I saw this moron shyster do this in a recent city council meeting, well, I just couldn't resist.
Hey, Brian. We don't mean to interrupt nap time,
Can we get your name for the record? I'm sorry.
but can you have at least the decency to not snooze while we're talking to you?
Can we get your name for the record, please?
No, so I'm no name, okay?
Fine.
I've now come to 2 council meetings, and you keep snoozing? What do we pay you, $50,000 a month sometimes on our dime for you to fall asleep in front of us? Can you at least pretend that you're interested in what we have to say? And you guys keep letting him fall asleep on us? Hey, wake up, Mr. Pierik. Nap time before.
A little payback can sometimes go down like a 40-year-old glass of scotch.